तो देखिए टुडे वी आर गोइंग टू डिस्कस व्हाट डू यू मीन बाय क्राइम and just we know that there are two terms, one is offense and second is crime. So today we will discuss today what do you mean by crime, and you know that the criminal law uses the term offense, and till date we do not have the satisfactory definition of the crime because it is not possible to define crime in the unanimous way. That would include act omission deemed to be criminal and at the same time exclude act omission that are not criminal. The concept of crime is subject to the spatial, temporal, and the societal variations. For example, the bigamy, which was considered to be the legitimate act, but with the passage of the time, the same is now being looked down and upon and has been made a criminal offense. But even today, there are certain societies that find nothing wrong in bigamy. Day by day, with the advancement of the field of the science and technology, we are becoming the witness of the advent of new crime that are completely unheard of earlier. Cybercrime is the example of this, and we made so many legislation with regard to this. So, in one case, which is the Sevak Perumal versus the State of Tamil Nadu, 1991, the Supreme Court observed that the crime is the societal phenomena which arises first when the state is organized. People set up rules, breaking of which was called crime. So many jurists have attempted to define crime in their own way. On the pursuit of these definition, one would observe that these definitions vary in many aspects, and let us have the glance at few prominent definition of the crime. Austin is the first. We will take firstly the Austin's definition. He said about crime, a wrong which is pursued at the discretion of the injured party or his representative is the civil injury. A wrong which is pursued by the sovereign or his subordinate is a crime. So he tried to distinguish between the civil injury and the crime, and he mean to say here that in civil injury the case can be filed by the injured party and he will just run the case. But, but in the crime, the case will run by the sovereign or the state. And Blackstone also tried to define crime, and he said crime is an act committed or omitted in violation of the public law. Forbidding or commanding it, it is the violation of the public right and duties due to the whole community. So he said that it is the violation of the public law. We know that there are two types of the law in broad perspective. One is public law and second is private law. So the violation of the public law is crime, and it is the violation of the public right also, and the public duties also. And Sir James Stephen, who also tried to define crime, and he said crime is an act which is both forbidden by law and revolting the moral sentiments of the society. So, history of criminal law, he said so about the definition of the crime, that it is denied by law and it is also against the moral sentiments of the society. Professor Kenny, who also defines crime in these words, crime are wrongs whose sanction is punitive and is in no way remissible. So remissible means here capable of the being pardoned uh, or remitted. So he said that crime are wrongs whose sanction are punitive, meaning thereby he is talking about the just sanctional quality of the crime. And he further says that by any private person, remissible is the crime is not remissible by the private person but is remissible by the crown alone, if remissible at all. So he said that state can just remit, or it is remissible by the state only or the crown only. Huda is the next who said that crime is an act that we consider worthy of serious condemnation. So he says that the act which is worthy of the serious condemnation or serious criticism is crime. Thank you very much.